The please, Lordship.
Yes.
Lordship, I wish to mention item number 15, Lordship.
Item number
15, 15.
15. Thing of matter. Criminal appeal of 12.
Lordship.
Why?
Initially, in this case, I was there, Lordship, but as per order of the Honorable Court, two immediate courier has been appointed, Lordship. So my name is maybe struck out from the case, Lordship. That is my prayer.
Let the matter be called.
Lordship.
Let the matter be called.
Lordship, I
Yes.
beg to make mention of item 11, Lordship. It's also a 2012 matter, Lordship. I have taken the consent of Mr. Kamar I've taken the consent of Mr. Kamar with respect to item 11, Lordship.
Yes, yes.
If it can be after 2 weeks, Lordship.
All right. As prayed for by Mr. R.K.P. Chaudhary, learned
Deputy SGM, Lordship.
deputy,
SGM, Lordship.
not as a special prosecutor.
That is yet to come, but as a
Okay, okay. All right. Deputy solicitor
yes, Lordship.
for central government, with consent from Mr. Jed Kamar, learned senior counsel, appearing for the appellant, relist
Let it be after 2
after
weeks.
2 weeks on a date to be fixed by the registry.
So
May I please? I need to mention item number 27 is matter of 2012 matter. What happened matter on this matter? Engaged counsel Mr. F. is lost from he left the practice, and Dr. B. Ahmed he also bedridden my lord. And another counsel Mr. A. Rahman, he also left the practice, my lord.
This is kept for dismissal. Please
Yes, my
wait.
lord. Yes, my lord.
Wait.
And then we could not.
Wait for your turn. Yes.
Hey, please, Lordship. Lordship, I beg to mention item number 13, Lordship.
1-3.
1-3. Lordship, can it be after 2 weeks,
As
Lordship?
prayed for by Mrs. MS
M. Nidal.
M. Nirula, learned counsel for the appellant, which is not opposed by the other side, relist after 3 weeks on a date to be fixed by the registry.
Oblige, Lordship.
This is item number
1-3-13. Oblige. Lordship, I beg to mention item number 29 of supplementary list.
Yes, this is again an counsels. These matters have been fixed today with remark for dismissal. So have the courtesy to wait for the matter to be called out. Whatever you have to say, you say it at that time. Yes.
Lordship, kindly
Lordship,
my senior is
you-
out of station.
Is there any difficulty, ma'am, for understanding the language that this court speaks? Yes.
Lordship, kindly adjourn the item number 21 and 22 for the day. My senior is out of
21 to?
station. 21 and 22.
21 and 22.
Yes, sir.
Your senior is out
Out
of
of station.
Mr. Who's
80,
your
sir.
senior?
80 Sarkar.
Sarkar. Yes, Mr. Chaudhary, any objection?
No, Lordship. I am
Uh,
here for item number 21.
All right. And who is, and in item 22, Mr. Mohanto is appearing. Have you informed?
Yes,
Have you informed
yes.
the office of Mr. TJ Mohanto?
80 Sarkar, sir, has informed.
That, all right. Informed, right? As prayed for by MS,
SR Das.
SR.
SR Das.
SR Das, Learned Counsel for the respondent number 2, with consent from the other side, relist after 4 weeks on a date to be fixed by the registry.
Lordship, in item number 21, there is an interim order.
Interim, if any, shall continue till the next date of listing.
Deeply obliged.
May it please your Lordship. Lordship, item number 9, Lordship. Kindly adjourn this matter, Lordship, and fix it on after verification, Lordship. We have to
Why?
take some- We have to take some instruction, Lordship.
What instruction?
Lordship, it's an old matter, Lordship.
Yes, it is a whole matter. That is why it is listed. These criminal revision petitions are pending from 2011, 12. All right, as prayed for by Mr.
D. Kolita.
D.
D. Kolita.
D. Kalita, Learned Counsel for the petitioner, which is not opposed by the other side. Relist after 2 weeks on a date, relist, date didyog after Bihu. Yes, call the list, please.
On admission, item number 1.
May I please, Lordship?
Yes,
Lordship, we are supposed to file an affidavit on behalf of the respondent, Lordship. Lordship, same is ready, Your Lordship. We'll file on Monday, Lordship.
last chance was given to you. Why have you not filed it today?
Lordship, some difficulties, Lordship.
What difficulty? This order was passed on 19th of March. Today is 28th. You had sufficient time.
Lordship, give us last chance, dear Lordship.
It's time that you take the orders of this court seriously. As prayed for, Mr. Your name?
R. Burman.
Mr. R. Burman, Learned Counsel, appearing for the respondent number 2, assures that the affidavit which was to be filed today will be filed on
Monday, Lordship.
Monday. In view of the said assurance, relist Tuesday or Monday is a holiday.
Oh,
By Tuesday,
Tuesday.
relist on Wednesday
Lordship.
or Friday, because he's going to file it.
Yes, yes,
But ensure you file it on that date. Otherwise, it will not be taken on record.
Lordship.
File by Wednesday, file by Tuesday, and relist on Friday.
Right.
You will have some time to go through it.
Yes, item number 2.
For dismissal, yes. Still nobody.
Lordship, here in.
Oh, you are there.
Yes, Lordship.
All right, fine.
I'm so sorry, last occasion.
That's all right. The purpose of putting it in the cause list with the remark for dismissal is to ensure that there is representation.
Exactly, Lordship.
So
Lordship,
since you have appeared, apology is accepted.
Lordship, here it is very unfortunate, Your Lordship, the appellant has already expired, Your Lordship.
Expired.
Yes, Lordship, but I have not filed any document, Your Lordship. So he was,
You obtain instruction.
no, Lordship, just telephonic instruction I received, Your Lordship. Lordship, it was happened long back, Your Lordship, between 14 to 15, Your Lordship.
No, why don't you ask someone to give you a
Your Lordship,
written instruction
Your
saying
Lordship,
that he has expired and you put it here, and or you want what do you want today?
Lordship, I have submitted before this court, Your Lordship, but unfortunately it was not recorded, Your Lordship. Actually, 22 to 2019, yes, I have already.
Nothing is recorded.
Nothing is recorded, Your Lordship. It is very.
No,
Lordship.
but then what happens? Petitioner has died.
Yes, Lordship, Lordship. Appellant, Lordship.
This is a criminal revision petition.
Exactly, Lordship.
Then why appellant?
Because it was against
Earlier-
the trial court's order, they have appealed in the
But the
Sessions Court,
and
Lordship.
it was upheld, Your Lordship. Subsequently, we came before Lord.
So you are the petitioner.
Yes, Lordship.
And say petitioner, you're confusing this court by saying appellant.
Lordship.
Now, then nothing survives.
Nothing survives, the 94 CRPC
Close it.
matter, but abetting.
Lordship.
Uh,
But case is very simple, just erosion negligence driving, Your Lordship. Was,
Then if he's there, either on your submission that he has expired,
yes,
I
Lordship.
can
That's
close
what I
it.
Disposed
explained.
of this.
Heard, Mr.
PK Medhi, Lordship.
Huh?
PK Medhi, Lordship.
PK Medhi, right?
Yes, Lordship.
Mr. PK Medhi, Learned Counsel for the petitioner, stop. Also heard MSSH Bora, Learned APP for the state respondent, stop. This matter was listed today with the in the order column, don't say in the order column, with the remark for dismissal in the cause list. As on the last occasion, I-25/3/2025, but the matter was last listed, there was no representation on behalf of the petitioner. Stop. Today, when the matter is called, Mr. Medhi has entered appearance. Mr. Medhi, Learned Counsel for the petitioner, is present. Stop. Mr. Medhi further submits that pending the revision petition, he has been instructed, he has received instruction that the petitioner has expired. He accordingly submits that in view of the death of the petitioner, the matter has become infructuous. Correct.
Yes, Lordship.
In view of the aforesaid endorsement made by the Learned Counsel for the petitioner, the criminal revision petition stands closed on being infructuous. None appears for the petitioner on call. heard MSSH Boral and APP for the state respondent. This matter was fixed today with the remark for dismissal in the cause list. In view of, as on the last occasion, I-21/3/2025, also there was no representation on behalf of the petitioner. It further appears that don't say anything. In view of the fact that there is no representation consecutively for the last two occasions, the criminal petition stands dismissed for non-prosecution.
Item number 4.
একই order এ দিবা, last date হচ্ছিল 21/3/2025. Same order, dismissed.
Item number 5.
বুঝি পাইছা না প্রণব? Yes, Mr. Sattar,
My lord, I have already filed that affidavit for withdrawal of my wakalatnama, my lord.
huh?
For withdrawal of my wakalatnama.
Oh, this is that case.
That case, my lord. And I have already annexed the photostat copy of that.
You have annexed what?
The letter which was sent to the petitioner, my lord, and then the postal receipt.
When you have filed an affidavit?
Yes, my lord. It was filed on 10/3/2025. Your lordship's earlier order was, my lord, on 7/3.
Yes. Let me see where that affidavit is. 10/3, yes. And when did they receive this?
My lord, on 12/11/2024, I had sent the notice. That is annexure B, my lord, page number 27.
Page number?
27, serial page 27, my lord.
And this was received when? 12/11 you had sent? When was it received?
No receipt, my lord.
What is
receipt.
this, what is
Otherwise-
this
otherwise it-
document at 26?
My lord,
Document number at 26 is what?
26 is, my lord, the postal receipt where my name is appearing for as a sender.
All right, heard Mr. S. Sattar, Learned Counsel for the appellant. Stop. Also heard MSSH Bora, Learned APP for the state respondents. It appears that, no, on the last occasion, Mr. Sattar, Learned Counsel for the appellant had submitted before this court, last occasion, I-7/3/25, that he had informed the appellant that he shall no longer continue with the case. Way back in 2000, way back on 12/11/2024.
4, yes, sir.
However, neither the appellant has contacted him nor has made any alternative arrangement in the matter. This court accordingly directed the appellant, Learned Counsel for the appellant, to bring the said letter on record by filing an additional affidavit.
Yes, ma'am.
Today, when the matter is called, Mr. Sattar draws the attention of this court to the affidavit filed on 10/3/2023 pursuant to this court's order. So, a perusal of the aforesaid affidavit indicates that a letter through registered AD was sent on 12/11/2024 to the address of the appellant clearly expressing the learned counsel's desire for not to appear in the appeal either by himself or through any of his juniors, and asked the appellant to collect the brief and all other relevant documents back from his office. Stop. It appears that despite the aforesaid letter, no, the appellant has neither contacted the learned counsel for the appellant nor has made any alternative arrangement in the matter. Stop. Ms. Bhuya, you are appearing in this matter?
Lordship, no. I'm not.
Stop. Yeah, my case are listed, yes. In view of the above, keeping in mind that this is a appeal, comma, this court deems appropriate to appoint এখন নতুনখনে না Mr. Rakesh Sharma as amicus curiae to represent the appellant in the appeal. Let the name of Mr. A. Sattar and his juniors be struck off from the cause list. Let registry furnish the copy of the appeal memo along with the relevant documents to Mr. Rakesh Sharma, learned amicus curiae. Let registry reflect the name of Mr. Rakesh Sharma, learned amicus curiae in the cause list on the next date of listing.
Yeah.
Relist after date
After
did you?
2 weeks.
April or last of on such and such date for hearing. This was already in hearing, isn't it?
Yes, Lordship, since this year has received.
No, but was it already in hearing?
Yes, it was for others, Lordship.
No, today it was ordered because of that submission.
Yes, since
Yes, it
this
is
year has
admitted.
arrived, that the matter we fix for hearing.
That since the trial court records have already been received, relist the matter on such and such date for hearing.
Please.
Yes, 27.
Dismissal.
Where is that lawyer gone? Someone, I think there was a girl was trying to mention this,
27, Lordship, yes.
isn't it?
Yes.
Very difficult. Yes,
My lord,
27.
yes, my lord. My lord, kindly pass over for timing, my lord. The concerned advocate is leg on court number 19, my lord.
That's all right. If there is a representation of the concerned advocate, then this matter, I shall fix it for, this is not yet admitted. Yes, admitted. I'll post it for hearing. Ms. Bhuya, you're appreciating this.
Yes.
Today it
is
was
state, my
fixed because there was no representation on behalf of the petitioner on the last date. That is why I had fixed it for, with the remark for dismissal in the ordered column, but now they have appeared.
It may fix for hearing then.
Heard Mr.
M. Hussain, my lord.
M. Hussain, learned counsel for the petitioner. Also heard MSB Bhuya, learned senior counsel, assisted by MS R. Das, learned counsel for respondent number.
And for the state,
Okay, then learned senior counsel and.
oh, there's one private respondent whose name is not shown in the cause list.
Learned senior counsel stroke, additional public prosecutor.
Lordship, but we are for respondent number 2 For R1, somebody SK Day and
No,
another.
that is why I'm asking. You
Yeah.
are for the
I am
state.
for the state.
So as APP, right?
Yes, right?
As APP, huh? For the state respondent is stop Koediba. I'm not saying anything about the respondent number 2 because there is no representation.
Yes, whether notice has been issued or not. 2012
Notice is
matter.
not issued. Surprisingly, looks like notice is not issued. The order of 21, whether it was admitted for hearing, call for records. I think inadvertently
Something.
something has gone wrong. Then what is to be done? Who is the respondent number 2? The
Mhm.
informant.
Fine now.
You have come without the file.
Yes, my lord, I am not in the case, my lord.
It's very easy to say you're not in the case. Number 1 is the inspector of factories. It's a official respondent, it
But
seems.
in the cause list, SK Day and another. has been
By
shown.
person,
My lord.
rate, by name.
My lord.
तेजा तुम्ही last की लिखी ना एको लिखा नहीं ना it appears that this matter was listed today in the order column with the remark for dismissal. As on the last occasion, i.e. 26/3/2025, there was no representation on behalf of the petitioner on call. Stop. However, today when called, Mr. So-and-so Learned Counsel is present on behalf of the petitioner. MSB Bhuya, Learned Senior Counsel, draws the attention of this court that though this matter was admitted for hearing way back on 21/1/2013, however, it appears that no notice has been issued upon respondent number 1, i.e. Shri S.K. Das, Inspector of Factories, in charge District Factory Office, Silchar, PO and PS Silchar, District Kachar, Assam. ठीक है हाला बेसी फास्ट होल नहीं
If he was the, this is a food, I don't know under what section it was registered, your lordship. Even I am without the
yeah,
brief.
I know Factories Act.
Factories Act. Then, lordship, then
You can accept.
lordship. Probably we can, on his behalf, we can appear as a state.
See, but there could be Malafaidi or something. I don't know why his name is.
My lord.
You do one
Oh,
thing,
returning.
you obtain instruction if you can
Yeah.
appear.
My lord.
And if you can appear, then, or should I take it after some time? You
Because
can
I
find
am
out.
without the brief, lordship. I am not aware.
You
of
are
what
without
it-
the brief.
Yes, lordship. State of Assam, your lordship understands.
See, if I issue notice now, we don't know how much time it will
Yes,
take.
my
It's
lord.
2012 matter.
For NG of Justice, Amicus, can it be appointed?
But notice only not gone now, Miss
Okay.
Priya. Then I say that in all fairness, you've said that since it's a governmentary, you will accept notice and try and send a letter to this address and find out through your office so that he knows. So
Fine.
if there is something for him
My
to
lord.
content, he can content. Eat cola.
To my lord. It slips the whole-
Oh, stop. B. Bhuya, Learned Senior Counsel, in her usual fairness, submits that since respondent number 1 is a government officer of the
Probably, I'm not aware of my lord.
Inspector of Factories.
My lord, then. I'll do not my lord. I'll do not.
The prosecution case was that during inspection
By that authority,
by
by
one.
that officer.
So he has done the inspection.
My lord.
So he has to be, isn't it?
Oh, by name of his second. For that reason, maybe it was, was not issued, my lord. Who will represent him?
Respondent number 1 being the Inspector of Factories who had conducted the inspection in question in the factory premises of the petitioner, comma, she accepts notice, she or your junior,
My junior.
uh, her junior MS so-and-so accepts notice on behalf of respondent number 1. Let extra copies be served upon MS so-and-so,
Ardas.
learned counsel for the respondent, Accordingly, notice stands complete. Shall I post it for hearing?
Yes, ma'am.
Let the matter be posted for hearing. When? In the month of
12
May,
Well,
in the month of May on a date to be fixed by the registry.
Most of them.
Mr. Counsel, I hope you have understood what has happened. So please ask whoever are the concerned lawyers to furnish a copy of the revision petition to MS Das. Das, right?
Yes, ma'am.
Item 28.
Yes.
May it please, your Lordship. Lordship, in this matter, Mr. Khandelia is appearing, is the contending counsel. He has also submitted a leave application also due to his unavailability, Lordship.
No, but that is all right. On the last occasion, there was no representation, and it appears that there are three names reflected
Yes,
in the
Lordship.
cause list
Yes, Lordship.
representing the petitioner. It's a 2019 matter, old matter. Why there was no
Apology,
representation?
my lord. Apology, my lord.
All right, accepted. Your name?
D. Rathi.
his name is not shown in the cause list.
I'm
He's not-
appearing on behalf of the contending counsel, Mr. Khandelwal, and also my senior, Mr. Amit Goel.
Where is Mr. Goel?
Currently in legs at court number 2, Lordship.
And Mr. Khandelwal has given a leave of
Leave
absence. All right. Third, Mr.
Rathi, D. Rathi.
A.
D. Rathi.
D. Rathi, learned counsel for the petitioner, also heard MSB Bhuya, learned senior counsel, assisted by MS Ardas, learned counsel,
R2. She is appearing for R2.
learned counsel for the
R1.
learned APP koribole B Bhuya, learned counsels for the state respondent, as well as MS
Naam to ko?
Lina Sharkar, L Sharkar.
L. Sharma.
L Sarkar.
L. Sarkar, learned counsel appearing for the respondent number 2.
1.
Right? Sorry, 1. Because of the air conditioners, sometimes it's very difficult
Happens, my
to
lord.
hear clearly the names.
Right.
This matter was listed today in the order column with the remark for dismissal. As on the last occasion, i.e. 26/3/2025, there was no representation on behalf of the petitioner. So, however, today, when the matter is called, Mr. So-and-so Rathi, learned counsel for the petitioner is present. Is present. This matter was earlier,
26th March.
no, it had come for what, hearing?
Lordship, we had to file an additional affidavit.
You will file an additional
Yes,
affidavit.
Lordship.
Mr. Rathi, further 2 weeks' time to file an additional affidavit in the matter, which is not opposed by the other side. Relist after 2 weeks on a date to be fixed by the registry.
My lord, there was a previous interim order. If the
Interim, if any, shall continue till the next date of listing.
deeply obliged, ma'am.
5/9.
Yes. Why were you absent on the last occasion?
Lordship, my senior is out of station.
That is a ground for non-appearance of matters when they are listed before the court. Such casual approach.
I am not aware with the facts of this case.
That is the problem. You must check the cause list every day of your senior and find out when the senior's matters are there and do whatever is required to be done. You cannot leave matters unattended in the court. Your name?
Okay, Petrica.
I'm fixing it for What was it? I'm sure she will not know. Ms. Bhuya, I think, yeah, it's already admitted and the scan copy has already been received. I sent a scan copy.
Yes, it's showing us.
Yes.
Scan copy.
MS,
Namtuka, your name?
A Petrica.
heard MSA Petrica, Learned Counsel for the petitioner. Stop. Also heard MSB Bhuya, Learned Senior Counsel, stroke APP, assisted by MSR Das, Learned Counsels for the respondent number 2. State respondent number 2. Anyone for private respondent? Nobody. None
Will be
appears.
for R1, State of Assam and another.
Okay, I don't think there is any private respondent here.
Showing in the cause list
This
another.
is item 29.
State of Assam and another. As a file to?
Yes, you are right. There is someone else. But notice was issued through court.
What are the files here tonight?
Notice is deemed to have been completed. It appears, no, sorry, की भी लिखी ना? नाम है लिखा ना? This here for something actually लिखी दिया अजी fix course with the remark for so and so. Last date to है 26/3/2025. ठीक है? After this you write that however अजी I नाम से India so and so Petrica is present when the matter is called. Stop. It appears that though service upon respondent number 2 was deemed to be completed by order dated 10/8/2022. However, there is no representation on behalf of the respondent number 2 till date. It further appears that the scanned copy of the TCR has been received. Let the matter be listed for hearing, right?
For hearing.
I'm not finding the admission order. All right, hearing. In the month of May 2025 on a date to be fixed by the registrar.
For hearing item number 6.
Your Lordship, in the last location, I made a submission that we are not able to locate the file, Your Lordship. It's an old pending matter, Your Lordship. But till now, we are unable to locate it, Your Lordship. And
Why have you not made an effort to look into the papers? You
Your
can always
Lordship.
approach the registry and have a look at the file.
Your Lordship, today I have looked the file, Your Lordship, and Your Lordship, I have also contacted the other council also in the cause list, Your Lordship. From him also, I didn't receive any positive response.
Sorry, you have?
I also contacted the other council in the cause list, Your Lordship, G. Kakoti, Your Lordship. From him also, I did not find any positive response regarding the brief, Your Lordship.
No,
And
no, you are appearing for
For Jed Alam, Your Lordship.
you are appearing for Jedala.
Yes, Your Lordship, Jed Alam.
And then you have a file. I'll ask registry to supply the appeal memo with the relevant documents to both of you then. Heard MS S. Nazik. Nazni, Learned Counsel, appearing for the appellant, also heard Didiba, MSB and all that. MS S. Nazni, Learned Counsel for the appellant submits that despite of trying to locate the appeal file, she could not do the same and could not do the same. Stop. MSB Bhuya so and so also submits that the copy of the appeal memo is not available in the office of the
Public
PP
prosecutor.
Assam. Let registry furnish a copy of the appeal memo along with all the relevant documents to MSB Bhuya Learned Senior Counsel, State Respondent, as well as MS S. Najni Learned Counsel for the appellant. Relist for hearing in the month of June 2025 on a date to be fixed by the registry.
Deeply obliged.
No.
There will be no representation when these revision petitions are called, and when you fix them for dismissal, then somehow the lawyer starts coming. Alabdi Rakha.
Take the file as a no.
No complaint. I am for opposite party number one. The complaint-
Same.
Same. Petitioner is not there. Same is.
Lucky. I'll fix it for then on Wednesday for dismissal. Let me see last time whether, oh, the last
that will
time
also
it came in 2012.
12. After a
Uh,
long time it has come.
We'll put it for dismissal. If anybody appears, will appear, otherwise we'll.
Last chance may be given to them.
No, none appears for the petitioner on call. Heard Mr. D. Talukdar, learned counsel appearing
OP number one.
for the respondent number one. PP is there, state
They
is
are,
there.
they are formal party.
And so MSB VR team for it. It relist on Wednesday, I so and so in the order column with the remark for dismissal.
Master.
7-2 dia. 7-2 same kore dia. Khali 7 not mark the presence of MSB Bhuya. Wednesday. See, the court will function if this is how the petitioners, lawyers behave in matters which are of 2012. And it surprises me that when you relist it with the remark for dismissal,
They appear.
they appear. That means they see.
Yes.
I don't want to make such statement, but it appears, isn't it? Same. Mark presence of Mr. Gupta for respondent number,
Sole respondent. my lord.
sole respondent. H. Gupta, for the respondent.
Like,
Wednesday. See, Ms. Bhuya, same. Put it on Wednesday.
My lord.
Here you are there.
Yes, we are
In
there.
12, you mark
Nine.
MSB Bhuya's presence. Same order. Ms. Bhuya, you are there?
Lordship.
Yes, mark up it.
So initially, I was in the case lordship, but on the last that lordship, the honorable court appointed immediate curie in this case lordship.
You are, but if you are there, why do you want to withdraw your name from the, you be there with the amicus?
Lordship, what happened, Lordship? In this case, Lordship, I have been appointed by colleague advocate, Lordship. There was no communication from the appellant.
Ms. Bhuya, can you ask your junior to send a message to Mr. Fukan? He's,
Aruna,
I think his name is 15.
15, Lordship.
what are the numbers?
There are two amicus curie names. So I
Yes,
don't know why.
Rakesh.
I don't know who is appearing.
Person has been appointed, Lordship.
Hmm?
Two amicus curie has been appointed, Lordship.
Yes, how, why
It
two has
has
been
not.
appointed?
Their names are also reflected in the first list.
I think this Rakesh Sharma is a different one. He, I think, has already, his name has been removed from the list because I think he desired. I remember seeing that. That there are two Rakesh Sharma. This is not, this is different. Maybe that's why A. Fukan has been appointed, but I don't find any orders. Yes, yes. Office note is there. And there is an order of the court also. Okay. You have asked someone?
Yes.
Mr. Sharma, just wait for 1 minute.
Lordship.
Let Mr. Fukan come. In his presence, I'll, you don't want to appear in this, isn't it? All right. Wait for a while. Could she contact him?
Yes. He's coming.
Yes.
No, please, your lordship.
Yes.
Lordship, Mr. A. Sharma, the conducting council is on lag in another court. Lordship, the matter may be taken next week.
This is an opportunity for you.
A. Sharma is for the respondent, right? He's for the respondent? No, for the petitioner.
Yes,
Cannot
A.
be
Sharma is for the respondent in the cause
respondent
list.
as part of cause list. Wait a moment, 16? Oh, acha. I'm sorry, lordship. Come this way. Yes, come this way.
Not item 16.
Lordship, but petitioner is absent.
Appellant.
Appellant, my lord.
On the last occasion also, there was no appearance. Despite names of two councils. We'll appoint an amicus. You can't keep this statutory appeals pending because of no representation. Yes, Mr. Fukan, wait. Just take your seat. The next matter, you wait. In item 17, in item 16, Mr. Fukan.
What is
Mr.
that?
Fukan, in item number
15.
No.
Oh,
the
16, he'll be appointed.
In item 16, the engaged councils have been consecutively absent.
My lord.
So, would you like to assist the court as an amicus in item 16 as well?
My lord, I can.
Okay. Because your name is already there in the panel list, isn't it?
My lord, yes. I'm in the single bench. Single bench.
Yeah. This is single bench.
I know.
Amicus or legal aid?
None appears for the appellant on call. Mark the presence of Ms. B. Bhuya with her team. It appears that on the last occasion, I-37/2024, when the matter was last called, there was also no representation on behalf of the appellant, despite the names of two councils having been reflected on both the occasions. Stop. In view of consecutive non-appearance of the learned counsels appearing for the appellant, this court appoints Mr. A. Fukan, learned counsel, as amicus curiae to represent the appellant in the appeal. Let registry furnish a copy of the appeal memo along with the relevant documents to Mr. So-and-so Fukan, learned amicus curiae. I'll post it for hearing. I said to Harry Kini.
Cashier has arrived.
As the already, I think order assay is relist for hearing when Mr. Fukan.
After Bihu, my lord.
In the month of May 2025 on a date to be fixed by the registry.
My lord.
A learned friend is appearing for a respondent.
All right, you please mark upward likhe deba. Also, your name
G. Swami.
G. Swami, learned counsel, appearing for the respondent number 2. 2 to 7?
Yes,
2 to 7. All right.
His name be reflected in the cause list.
Right. Let registry reflect the name of Mr. A. Fukan as amicus curiae in the cause list for the appellant.
Deeply obliged.
Yes, item 15, I think your name is
My
reflected.
lord, what has happened is, my lord, in this matter, I have not been served a copy of the thing, my lord. of the paper book also.
All right.
Initially, Mr. R. Sharma was there, single bench, he, I think, is not no longer in the amicus matter.
I think because there are two Rakesh Sharma,
Not the senior one, ma'am.
Mm,
Not Mr. Digan
not,
Das,
not Mr.
yet.
Das's
No,
junior,
not
correct?
Mr.
That's what I was thinking.
Another one, ma'am.
Another
It's,
one. He, I think, because I remember letter was circulated
My
that he has expressed his
Non-willingness.
because of some personal difficulty
personal difficulty.
to withdraw his name from the penal list,
Penal.
for which it was withdrawn.
Right.
So that's why I think you have been
I have been newly
appointed.
appointed.
Anyway, but try and be in court when your name is then.
I was
because-
actually on legs, ma'am. Apologies.
No, no problem.
Well.
Even if you're on legs, next time you try to send someone, because you see, when you're appointed as an amicus curiae, it doesn't look good. I know there are times, sometimes you are in other leg, other court. There is no difficulty.
I'll ensure, madam.
All right. Heard Mr. Mr. A. Fukan, right?
No, no.
Learned amicus curiae for the appellant. Also heard MSB Bhuya, learned senior counsel stroke APP assisted by so and so for the state respondent. Stop. Mr. Fukan has submitted that that registry has not furnished the copy of the appeal memo with the relevant documents till date. Let registry furnish the same forthwith, relists for hearing in the month of
Me and madam.
May 2025 on a date to be fixed by the registry.
Deeply obliged.
I don't know, 17, my lord. Appellant number 1 died very long back.
He died?
Appellant number 1,
Criminal number 1,
petitioner number 1.
petitioner number 1.
And I also, my lord, could not contact the other persons. So, let the matter come after 3 weeks. And my lord, if lordship,
All right,
if
item-
lordship permit me to give a copy of the memo of petitions which are annexes,
Why?
because my petition is not available.
You have a look at it and registry will, if you see, you obtain, you apply through such.
I said,
copy,
I'll
the registry will not going to
I will apply.
deny.
I will apply it, my
You
lord.
apply, you don't need any permission from this court.
My lord.
Heard Mr. J. Ahmed, Learned Counsel for the petitioner, also heard anyone? No. None appears for the private respondent on call. Private respondent?
Yes. State also there. Later on, the state also make party.
MS SH Bora, Learned Counsel appears
That's what
for,
I was saying.
APP is present for the state respondent. What about the notice to the private respondent? Is it complete?
No,
or
Mr.
not?
Mr. Rosid appear.
Someone is there.
Rosid
His
appear.
name is Sonin
Okay,
across
okay. All right. Mr. Ahmed, Learned Counsel for the petitioner, submits, seeks some accommodation in the matter as he has as the file and
I-
the relevant papers has been misplaced. And further, he has received instruction, you have received instruction that one of the petitioner, that the petitioner number
One.
1 has in the meantime expired. And accordingly, he misplaced file to Kosanokoma, seeks, submits that the petitioner number 1 pending the revision petition has expired and accordingly wants to do.
No, let it there, I'll get confirm information. my lord.
However, he does not have written instruction in this regard and seeks accommodation to obtain the requisite instruction in this regard. Prayer is not opposed, relist after 4 weeks on a date to be fixed by the registry.
Hello.
Hey, same order, Nilima. Oh, wait. Last time on asile. Dismiss kon. None appears for the petitioner on call. MS SH Bora, heard SS Bora at APB for the state respondent. It appears that on the last occasion, I-9/6/2020, also there was no representation on behalf of the petitioners. However, this court for the ends of justice adjourned the matter. Today also, when the matter is called, unfortunately, today also when the matter is called, there is no representation on behalf of the petitioner. That being so, the revision petition stands dismissed for non-prosecution.
Also, nobody is appearing for the petition. 19 also, nobody is appearing
Yes, but I'm just checking if they had appeared.
in the other occasion.
All right, for Wednesday, order column with remark for dismissal. And here, SH Bora, APP. Wait.
Here in this case, I am appealing for the respondents, but let's say here in this case, what happened, there were another case is also pending. Here, this matter relates to domestic violence.
But there is no appearance on behalf of the petitioner.
Yeah, still I'm referring to, I'm placing for lordship that the other case may be tagged along with this case.
I think since there is no representation, I'll fix it on Wednesday for dismissal. There is no representation on behalf of the petitioner on call. Mr. A. Ahmed, Learned Counsel, appearing for respondent number
Respondent number
2 and MS SH Bora, Learned APP for the state respondents are present. Relist along with
that is criminal appeal number 104 of 2020.
I am not doing that. On that date, you can make that. Relist on Wednesday in the order column with a remark for dismissal. Mr. Ahmed also draws the attention of the court a connected matter being
Criminal appeal number.
criminal appeal.
Lordship.
That's a criminal appeal.
Criminal appeal.
Then hetu na lage.
Next week, any day, my lord, we need to get some instruction regarding this matter, my lord.
Your name?
D. Bora, my lord.
D.
D. Bora.
D. Bora. Mr. D. Bora, Learned Counsel for the petitioner, praise accommodation in the matter which is not opposed by MSSH Bora, Learned APP for the state. Relist
We need to get some instruction from them, my lord. Then we can continue.
On the ground that on the ground for obtaining instruction in the matter. Relist after 3 weeks on a date to be fixed by the registry.
God bless.
Yes, Mr. Padgiri.
In pursuance of the order, my lord, dated 23/3, my lord, the registry of this honorable court appoint the amicus curiae, my lord. Flag A, my lord. Appoint the amicus curiae, my lord.
On behalf
For respondent number 2.
his name is not shown in the cause list.
Amicus curiae has been appointed.
Devoshri Soika. No. 76.
It appears that the name of MS Debashri Saikya, Learned Amicus Curiae,
For respondent number 2.
for appointed to represent the respondent number 2 is not reflected in the cause list today when the matter is listed. That being so, let relist on Friday, next Friday, on such and such date with by reflecting the name of MS Devashri Saikya, Learned Amicus Curiae for the respondent number 2.
Interim order, my lord.
Interim, if any, shall continue till the next date of listing.
Obliged.
Report be given, heard Mr. K.R. Padgiri or S.H. Bora for the state respondent. Yes, Mr. Chaudhary.
Me, please, my lord. My lord, this is a quashing application. Primarily, the dispute is between the husband and wife. Primarily, the dispute in my humble submission is a matrimonial dispute. The petitioner number one in the instant case and the respondent are husband and wife. And the petitioner numbers 2 and 3, they are the father-in-law and
Who are husband, wife?
the petitioner number one, my lord, Rojibon Nessa,
P1 and,
the respondent, sole respondent.
no, wife is, oh, sole respondent,
Husband is the sole respondent. He is the complainant.
correct. So P, sorry, P is the husband.
P1 is the wife. The petitioner number one is the wife, my lord.
Sorry. P1 is the wife and R is the husband. Sorry,
Yes,
I got it wrong when you.
my lord, that is the peculiarity of the case, my lord. Generally, these sort of cases are filed by the wife against the husband. And
So
the
you are
petition-
for the wife.
I am for the wife, my lord. And the petitioner numbers 2 and 3, they are the mother-in-law and the father-in-law of the
2 and
respondent.
3. Okay. Where is the
My lord, the complaint in
complaint? You are seeking quashing of the
quashing of the
complaint.
complaint, my lord. The complaint in vernacular is at page 13.
It's registered under 406,
406
breach of trust,
breach of trust, my lord.
and 506. What is
506?
506?
My lord, criminal intimidation.
Yes, page,
13, my lord.
yes.
Is-
Cognizance taken, not taken,
Cognizance taken.
taken.
Taken. The order is at page 23.
Under 406, 506.
406 and 506, my lord.
Okay, all right. Yes, please read.
মানে from the bottom, 1 নম্বর আসামি জনী গুছরিয়ার স্ত্রী হয়, 2 নম্বর আসামি জনী গুছরিয়ার হাহু আই হয়।
But the translated copy is
Translated
there.
copy is there at page 10, my lord.
Any reason why you want to?
No, my lord, that is normally the vernacular.
Yes, please read.
It is a submission of the complainant that accused number 1 is the wife of the complainant, accused number 2 is the mother-in-law, and accused number 3 is the father-in-law of the complainant. On 7/10/2018, the complainant married the accused number 1 and moved into the house of his in-laws in order to stay with them. After their marriage, the couple lived peacefully for approximately 2 months. However, the accused number 1 thereafter started demanding the below mentioned articles from the complainant.
Slowly,
I'm sorry.
read slowly.
However, the accused number 1 thereafter started demanding the below mentioned articles from the complainant as per the ill advice of her mother and father, that is, the accused numbers 2 and 3. The accused number 1 threatened the complainant to withdraw from his company as a wife if he failed to procure the demanded articles. The complainant, for the sake of maintaining the marriage, procured the demanded articles one by one by means of his hard-earned money. The household remained peaceful for 2-3 days after receipt of the articles which were demanded. Thereafter, the accused number 1 again started to threaten the complainant of ending their marriage through various means. With no intent to continue with the marriage, the accused number 1 on 19/7/2019 ousted the complainant of their house and also threw clothes and other belongings out of the house. The complainant was forced to leave after he was thrown out of the house. The complainant, with the intention of reconciling his marital ties on 3/8/2019, went to the house of the father of the accused number 1 along with the witnesses and asked the accused number 1 to reconcile and continue as a family. But the accused numbers 2 and 3, upon hearing such pleas of the complainant, became furious and verbally abused the complainant. The complainant asked to take back the aforementioned articles acquired by the accused number 1 but the accused number 1, I'm sorry, my lord, there is a typographical error, but the accused number 1 did not want to continue with the marriage, did not allow him to do so, and further obstructs any future attempt of the complainant to retrieve the articles. The complainant is further threatened that any attempt to act otherwise would result in his death, and saying so made him leave the place along with the witnesses. The articles given by the complainant are precious and essential. The articles will be misappropriated if left in the possession of the accused persons. Hence, it has become important to recover the articles from the possession of the accused persons. Accused number 1 has prepared a notarized talaknama. Photocopy of the same has been annexed herewith. It is therefore prayed that Your Honor, after perusing the records and through necessary witnesses and inspections, may be graciously pleased to pass an order directing the recovery of the articles from the possession of the accused persons. Well, the articles, if your lordship, comes to the list, it is one almirah, a showcase, a sofa set, a place for hanging clothes, one center table, a mobile handset, gold ornament. These are articles which were basically necessary for moving ahead with the household as a husband and wife. What I beg to submit here in my lord is that as per the provisions of section 403 of IPC, what is necessary
In
is that
406, I am convinced nothing is made out.
nothing in them.
Now, 506,
506, my lord, there
the
is a
406, there has to be,
entrustment of property, my lord.
406 is, there has to be fraudulent misappropriation. And that
First and foremost, my lord, they
Maybe,
have to be
and-
entrusted and then fraudulent misappropriation
that allegation, it doesn't appears to be in the body.
in the body. And basing on that allegation, my lord, a similar allegation has been made that that the complainant, who is the respondent, had arrived at the home, where the matrimonial home of the petitioner number 1 and asked back for his articles. And then he was turned back with a
When was
threatening.
that FIR filed? Prior or before?
My lord,
That FIR was filed when?
my lord, the single complaint has been filed, no other FIR has not.
Oh, okay.
This is mentioned in
No.
the complaint. My lord, what I submit is that the allegation which of 506, it also stems out from the allegation of 406, my lord, only the articles. The articles otherwise are movable assets. For preservation of the same, a civil suit could very well have been filed and the civil court was competent enough to pass appropriate interim orders for preservation of the property, and thereafter, if proved to the satisfaction of the court, a direction for recovery.
406, you said, no?
406, my lord. My lord, the last page.
406 and
506, read with section 34.
now. Entrustment has to be there.
Madam,
Unless
first and-
entrustment is there, no offense can be made.
But first and foremost, there has to be an entrustment and thereafter dishonest
There has to be
misappropriation.
an allegation. That allegation doesn't come out from the, Mister, you are appearing,
Lordship.
you will have to show how the ingredients of the sections are made out in the body of the FIR, okay? I'll come back to you. Mr. Chaudhary, what about 506? What are the ingredients?
506, my lord, the ingredients are that for 506, somebody has to be threatened with an injury either to his person, reputation or property, or to the person, reputation or property of anyone in whom that person is interested.
Well, I'll just reread, you can read that Assamese vernacular ones.
Yes, my lord. Page number 13 onwards. এক নম্বৰ আসামীজনী গুচৰীয়া স্ত্ৰী হয়, 2 নম্বৰ আসামীজনী গুচৰীয়াৰ শাহু আই হয়, 3 নম্বৰ আসামীজনী গুচৰীয়াৰ শহুৰ হয়। যোৱা 7-10-2018 ইংৰাজী তাৰিখে গুচৰীয়াই 1 নম্বৰ আসামীজনীক বিবাহ কৰাই তাইৰ মা দেউতাৰ ঘৰত ঘৰ জোঁৱাই হিচাপে থাকিবলৈ লয়। বিবাহৰ পিছত অনুমান 3 মাহমান দুয়েৰে ভালে ভালে ঘৰ সংসাৰ হয়। তাৰ পিছৰ পৰা 1 নম্বৰ আসামীজনী তাইৰ নিজ মা দেউতা অৰ্থাৎ 2 আৰু 3 নম্বৰ আসামীৰ সুবুদ্ধিত নিম্নলিখিত বস্তুসমূহ গুচৰীয়াৰ পৰা দাবী কৰিবলৈ আৰম্ভ কৰে। দাবীকৃত বস্তুসমূহ আনি নিদিলে 1 নম্বৰ আসামীজনীয়ে গুচৰীয়াৰ লগত ঘৰ সংসাৰ নকৰিব বুলি ভাবুকি প্ৰদান কৰিছিল। গুচৰীয়াই ঘৰ সংসাৰখন ভালে ভালে হোৱা খাতিৰত অতি কষ্টেৰে উপাৰ্জন কৰা টকাৰে দাবীকৃত বস্তুসমূহ এটা দুটাকৈ আনি দিছিল। দাবীকৃত বস্তুসমূহ আনি দিলে 2-3 দিনমান ভালে ভালে ঘৰ সংসাৰ কৰে। তাৰ পিছত আকৌ বিভিন্ন চলনাৰে 1 নম্বৰ আসামীজনীয়ে ঘৰ সংসাৰ নকৰাৰ ইচ্ছা প্ৰকাশ কৰে। নম্বৰ আসামীজনীয়ে ঘৰ সংসাৰ নকৰাৰ উদ্দেশ্যত যোৱা 19/7/2019 ইংৰাজী তাৰিখে আসামীগণে গুচৰীয়াক সিহঁতৰ ঘৰৰ পৰা খেদি দিয়াৰ উপৰিও গুচৰীয়াৰ পিন্ধা কাপোৰ কানি বোৰো ঘৰৰ পৰা বাহিৰত দলিয়াই পেলাই দিয়ে। গুচৰীয়াক খেদি দিয়াৰ পিছত উপায়বিহীন হৈ তাৰ পৰা গুচি যাবলৈ বাধ্য হয়। গুচৰীয়াই পুনৰ ঘৰ সংসাৰ হোৱাৰ আশাত যোৱা 3/8/2019 ইংৰাজী তাৰিখে সাক্ষীগণক লগত লৈ 1 নম্বৰ আসামীৰ পিতাৰ ঘৰত যায় আৰু 1 নম্বৰ আসামীক পুনৰ ভালে ভালে ঘৰ সংসাৰ কৰিবলৈ কয়। কিন্তু দ্বিতীয় আৰু তৃতীয় নম্বৰ আসামীগণে এই কথা শুনা পাই অতি ৰাগান্বিত হৈ গুচৰীয়াক বিভিন্ন অশ্লীল ভাষাৰে গালি গালাজ কৰে। 1 নম্বৰ আসামীজনীয়ে সংসাৰ নকৰা বাবে নিম্ন উল্লেখিত গুচৰীয়াৰ সামগ্ৰীসমূহ আনিব খোজাত আসামীগণে আনিব নিদিয়ে আৰু ভৱিষ্যতেও আনিব যাবলৈ বাধা প্ৰদান কৰে। ইয়াৰ অন্যথা কৰিলে অইন লোকৰ হাতুৱাই গুচৰীয়াক জীৱনে মাৰি পেলোৱাৰ ভাবুকি দি সাক্ষীসহ তাৰ পৰা খেদি দিয়ে। গুচৰীয়াই দিয়া বস্তুসমূহ অতি মূল্যৱান আৰু প্ৰয়োজনীয় বস্তু হয়। বস্তুসমূহ আসামীৰ কবলত পৰি থাকিলে তেওঁলোকে আত্মঘাত কৰাৰ পূৰ্ণ সম্ভাৱনা আছে। সেয়ে আসামীৰ কবলৰ পৰা সামগ্ৰীসমূহ উদ্ধাৰ কৰাৰ তদৰ্থে আৱশ্যক হৈছে 1 নম্বৰ আসামীজনীয়ে নটাৰী যোগে তালাকনামা প্ৰেৰণ কৰে ফটোকপি সংলগ্ন কৰা হ'ল। গতিকে প্ৰাৰ্থনা মাননীয় হুজুৰ আদালতে দয়া কৰি এই গোচৰ গ্ৰহণ ক্ৰমে সাক্ষীবাদী মূলে থানা তালাচী যোগে আসামীৰ কবলৰ পৰা বস্তুসমূহ উদ্ধাৰ কৰাৰ হুকুম দি সুবিচাৰৰ আজ্ঞা হয়। ইতি 22/8/2019 ইংৰাজী।
Anything to show that what has happened? You see, because on the face of these complaint, some allegations are there. Now, how can this court at this stage go into these allegations? Whether they are correct, unless of course it is absolutely absurd.
In case of 506 there might be. In
That's
case of
what-
406
No, 406 also, see, this is too early that you have come, isn't it? Now 406, it appears that these things were in the house. You're right, it is not saying entrustment. Maybe 406 is not a correct, but 506, something is there. Let's see
If I'm
506.
allowed to read 406, then after that
Yes.
I'll start with section 405.
Yes.
Whoever being in any manner entrusted with property or with any dominion over property dishonestly misappropriates or converts to his own use that property, or dishonestly uses or disposes of that property in violation of any direction of law prescribing the mode in which such trust is to be discharged, or any legal contract express or implied which he has made touching the discharge of such trust, or willfully suffers any other
Mr.
person.
Ahmed, of course, the husband will give a mobile to his wife.
Gold ornaments as well.
So in this
No,
case,
you cannot now, because this is not some contract, government appointment, that if something is given as an allowance, it will be taken back at the termination or retirement. It's not like that, isn't it?
this is not like that, but
Then,
yes.
now just because the wife has expressed her desire not to live with him and the talaknama has been given, now can he file an FIR saying, no, these things I have given, now you return? And what are these things?
No,
Godrej, Godrej, center table, Godrej Almeida, showcase made of steel, Alna,
that I have seen.
center table, Almira made of steel, one mobile handset, and gold ornament would be 6,000.
That I have seen.
As a husband, of course, he will give all this to his wife. Which husband will not give?
That-
So this to appear has been very less has been given.
Lordship. On that, Lordship, I am not commenting, Lordship, but
And now, because of the Talagnama, he is saying 406. How can it be? What is this breach of trust?
that, but here in this case,
406. I'm not convinced at all. Now let us see 50. 50.
3, my lord, would define
503.
criminal intimidation.
Yes, please.
My lord, 503 reads, whoever threatens another with an injury to his person, reputation or property, or to the person or reputation of any one in whom the person is interested, with intent to cause alarm to that person or to cause that person to do any act which he is not legally bound to do, or to omit to do any act which the person is legally entitled to do, as the means of avoiding the execution of such threat, commits criminal intimidation.
What are the ingredients of 503?
My lord, the ingredients first and foremost would be,
Are you carrying any authority?
my lord,
Are you carrying an authority on
Yes, madam.
506? Yes.
my lord, paragraph number 33 speaks of section 506 IPC.
Yes. Yes.
My lord, I may be permitted to read from
Yes,
paragraph number
please.
35 onwards.
Yes, please.
In the present case, the complainant does not specifically attribute any
Can we start from 33?
Very well, madam. This brings us to the offense under section 506 of IPC, which the High Court has found to be prima facie disclosed against the appellants. Section 506 of IPC prescribes the punishment for the offense of criminal intimidation, while section 503 defines the offense of criminal intimidation. This court had the occasion to examine the ingredients of 503 and 506 of IPC in Manik, Taneja and another versus State of Karnataka and another, where it was observed as follows. A reading of the definition of criminal intimidation would indicate that there must be an act of threatening to another person, of causing an injury to the person, reputation or property of the person threatened, or to the person in whom the threatened person is interested, and the threat must be with the intent to cause alarm to the person threatened, or it must be to do any act which he is not legally bound to do, or omit to do an act which he is legally entitled to do. In the present case, the complaint does not specifically attribute any threats or intimidation to the second accused. Therefore, ingredients of section 506 of the IPC prima facie are not made out against him. The argument that the first accused acted at the behest of the second accused is untenable, as section 34 of the IPC, which imposes vicarious liability in the criminal matters, has not been applied in the case. However, the complainant has stated in her complaint that she was threatened by the first accused as detailed below. Then on 25/10/2013 at about 2 p.m. and 3 p.m. one Madhushri Dotto HR asked me to forcefully resign, or otherwise I'll be sent out immediately. Further, she abruptly asked me not to come for my work henceforth. Before an offense of criminal intimidation be made out against the first accused, it must be established that she had the intention to cause alarm to the complainant. A review of the alleged threat reveals that the complainant is primarily alleging illegal termination, which constitutes a civil dispute. rather than criminal intimidation. It is also the appellant's case which has not been disputed by the complainant that the complainant has filed a reference before the labor court challenging her termination and seeking reinstatement along with back wages. Given these circumstances and the
right.
materials on record,
All right.
my lord, here too the case
Now,
is of a civil
let
nature.
us come to that part of the allegation of threat. The alleged threat, let us just read that part. You may read from the English.
My lord,
page
from the English
11. Yes.
translation. But the accused numbers 2 and 3, upon hearing such pleas of the complainant, became furious and verbally abused the complainant.
Which part are you? Okay, okay, yes, I've got
Mother,
it.
it's a big paragraph.
Yes, I've got it. Read, I have got it. I have got it.
But the accused numbers 2 and 3, upon hearing such pleas of the complainant,
When
became
three are the mother-in-law and father-in-law.
mother-in-law and father-in-law, my lord.
Hmm.
Acquired by the accused number 1 did not, I'm sorry, verbally abused the complainant. The complainant asked to take back the aforementioned articles acquired by the accused number 1 did not want to continue with the marriage, but the accused number 1 did not allow him to do so and further obstructs any future attempt of the complainant to retrieve the articles. The complainant is further threatened that any attempt to act otherwise would result in his death, and saying so made him leave the place along with the witnesses. Here to my lord, like the thing, like the case which I had referred to, my lord, here too, the father-in-law is accused of having threatened. The other, it mentions that he had, upon coming to know, he had obstructed the respondent from taking away the articles. And then again, in any case, my lord, this recovery of materials which are movable in nature or preservation thereof, in my respectful submission, would come under the domain of civil jurisdiction and can be tried by a competent court of civil nature.
You're carrying Bhajan Lal.
Bhajan Lal, my lord, I have the citation.
Okay,
But
Bhajan Lal to DVD. You're having? I have my copy. Mr. Ahmed, I'm expressing my mind.
Look.
I'm yet to hear you.
Look.
So don't get. See, reading of the FIR, the allegations, you have fairly admitted that 406 is not attractive. That's your fair submission. Also about 506, it appears it's very absurd about that threatening part also.
Right.
You see, the wife threatening the husband, I'll kill you.
Those allegations are
And that
there, but
also for what?
okay.
For those articles. For those articles.
Probably what I
No,
find.
and what are those articles? I have read it out to you.
That
Correct.
I have seen.
It doesn't
But what I have
seem
found.
very probable.
Lord.
But of course, this court is aware of the limitation that this court has in exercise of powers for quashing a complaint or an FIR.
Lord.
The principles are well settled,
Lord.
right?
Lord.
Now, assuming the allegation as contained as regards 506 is taken in its face value,
Lord.
reading the whole complaint,
Right.
if this court feels that it is absolutely absurd, no reasonable person can say, can this court still quash the FIR or complaint or not? This is the
This
question.
is the-
All right. That is coming in my mind. You will
Right.
have to address.
Lord.
Now, let us see Bhajan Lal
Right.
before I go to you.
Right.
You have it in your mobile.
I have the relevant paragraphs, my lord.
Paragraph
102.
102.
Yes, read 102.
In the backdrop of the interpretation of the various relevant provisions of the code under chapter 14 and of the principles of law enunciated by this court in a series of decisions relating to the exercise of the extraordinary power under Article 226 or the inherent powers under Article 482 of the code, which we have extracted and reproduced above, we give the following categories of cases by way of illustration wherein such power could be exercised either to prevent abuse of the process of any court or otherwise to secure the ends of justice. Though it may not be possible to lay down any precise, clearly defined and sufficiently channelized and inflexible guidelines or rigid formulae, and to give an exhaustive list of myriad kinds of cases wherein such powers should be exercised. Malak, after that comes
Yes, yes.
where the allegations, number one, where the allegations made in the first information report or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused. Number two, where the allegations in the first information report and other materials, if any, accompanying the FIR do not disclose a cognizable offense, justifying an investigation by police officers under section 156(1) of the code, except under an order of a magistrate within the purview of section 155(2) of the code. Number three, where the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offense and make out a case against the accused. Number four, where the allegations in the FIR do not constitute a cognizable offense but constitute only a non-cognizable offense, no investigation is permitted by a police officer without an order of a magistrate as contemplated under section 155(2) of the code. Number five, where the allegations made in the FIR or complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach a just conclusion that there is a sufficient ground for proceeding against the accused. My lord, I would please trust
Yes,
on this
I
and the
think
last one. my
principle
lord.
number 5.
5
is
and 7, my
applicable.
lord. Number 6, where there is an express legal bar engrafted in any of the provisions of the code or the concerned act under which a criminal proceeding is instituted to the institution and continuance of the proceedings, and or where there is a specific provision of the code or the concerned act providing efficacious redress for the grievance of the aggrieved party. Number 7, where a criminal proceeding is manifestly attended with malafide and or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal.
It prima facie appears that because if she had given the talaknama,
My lord.
this complaint has been filed. Prima
I
facie
would primarily rely upon point numbers 5 and 7.
5 and 7. Anything else? Complete 103 also. Do you have 103 there?
103, I do not have, my lord.
Mr. Ahmed, you have the decision?
Yes.
103.
We also give a note of caution to the effect that the power of quashing a criminal proceeding should be exercised very sparingly and with circumspection, and that too in the rarest of rare cases that the court will not be justified in embarking upon an inquiry as to the reliability and genuineness or otherwise of the allegations made in the FIR or the complaint, and that the extraordinary or inherent powers do not confer an arbitrary jurisdiction on the court to act according to its whims and caprice.
All right. Anything else you want to add? Or are you done?
My lord, one statement would be that the deposition of the witness, one of the witnesses who had allegedly gone to the respondent's in-laws house with him, he nowhere speaks, my lord, of any threat being adduced. That is at page 22 of the complaint.
Page?
22, my lord, annexure 3.
Where is it said that he had gone along with the complaints?
That in the complaint petition. My lord, otherwise, he has said the complainant with the intention of reconciling marital ties on 3/8/2019 went to the house of the father of the accused number 1 along with the witnesses and asked the accused number 1 to reconcile. This is at page 11. My lord, at the time of filing the statement.
Tohidul Ali?
My lord, one of the witnesses who had gone with him. At page 22.
Yes, he doesn't say anything.
My lord, he doesn't even make a whisper of any such threat.
Yes.
Or of
Where is the evidence showing that he had accompanied?
my lord, at the time of filing the
complaint,
filing of the petition, the copy of the deposition of the complainant was not available. Later on, an additional affidavit was
Please,
filed.
please
Madam.
give.
It is there on record. Yes.
And which is the order of the
Dated
magistrate
1st
taking
March
No,
2021.
the cognizance order which is challenged.
Cognizance order, my lord, is the last page, page 23.
Yes, the additional affidavit.
The additional affidavit, madam. Yes,
Yes, Rejibuddin Ahmed. He's the,
Rezabuddin Ahmed is
he's
the
the
respondent.
complainant. Yes,
Yes.
please read.
On 7/10/2018, my marriage was solemnized with Rojibon Nessa. I started residing at the house of my father-in-law, Rohim Ali. While residing there, I bought household articles, namely Godrej, showcase, Dunlop, Alna, bed, mattress, and blanket, one table fan, one ceiling fan, gas cylinder set. On 22/7/2019, my wife gave me divorce through court proceedings. On 3
There
5
is no whisper of these allegations. Mr. Ahmed, there is no whisper. It appears a very simple case. He was divorced by the wife, and when he wanted those articles, she refused. That's it. And he has nowhere said that this were given because she wanted. He simply said,
Here
I-
he says he had purchased those for.
correct. While residing there, I brought household articles, namely all this thing. My wife gave me divorce through court proceeding. On so and so, I along with Tahidul, so and so, and few others went to the house and asked them to return the articles. They did not return the articles and issued life threat to me. That's it. And this person does not, who went with him, what is his name? Tahidul.
Tawhidul Arim.
He does not say anything about the threat. He doesn't support him.
No.
Anything more?
Madam, lastly, although paragraph number 103 of Bhajan Lal says it should be exercised cautiously, I would just like to place one last
Yes, please.
decision of the Supreme. In 2023, CSCC 423. Deepak Gaba and others versus State of Uttar Pradesh.
Yes.
Then, madam, otherwise, this discusses about the ingredients of section 406. But I would just rely on paragraph number 21, second last page, where it
Yeah.
has been stated, my lord, that
Yes. Read.
I'll read the entire paragraph, my lord. We are
read the entire
therefore
paragraph.
of the opinion that the assertions made in the complaint and pre-summoning evidence led by respondent number 2 complainant failed to establish the conditions and incidents of the penal liability set out under sections 405, 420, and 471 of IPC, as the allegations pertain to alleged breach of contractual obligations. Pertinently, this court in a number of cases has noticed attempts made by parties to invoke jurisdiction of criminal courts by filing vexatious criminal complaints by camouflaging allegations which were ex facie outrageous or pure civil claims. These attempts are not to be entertained and should be dismissed at the threshold. To avoid prolixity, we would only like to refer to the judgment of this court in Thermax Limited and others versus KM Johnny, as it refers to the earlier case laws in copious detail. In Thermax Limited and others, it was pointed out that the court should be watchful of the difference between civil and criminal wrongs. Though there can be situations where the allegations may constitute both civil and criminal wrongs, the court must cautiously examine the facts to ascertain whether they only constitute a civil wrong, as the ingredients of criminal wrong are missing. A conscious application of the said aspects is required by the magistrate, as a summoning order has grave consequences of setting criminal proceedings in motion. Even though at the stage of issuing process to the accused, the magistrate is not required to record detailed reasons, there should be adequate evidence on record to set the criminal proceedings in motion. The requirement of section 204 of the code is that the magistrate should carefully scrutinize the evidence brought on record. He or she may even put questions to the complainant and his or her witnesses when examined under sufficient grounds for summoning the accused to stand the trial. Summons should be issued. Summoning order is to be passed when the complainant discloses the offense and when there is material that supports and constitutes essential ingredients of the offense. It should not be passed lightly or as a matter of course. When the violation of law alleged is clearly debatable and doubtful either on account of paucity and lack of clarity of facts or on application of law to the facts, the magistrate must ensure clarification of the ambiguities. Summoning without appreciation of legal provisions and their application to the facts may result in an innocent being summoned to stand the prosecution or trial. Initiation of prosecution and summoning of the accused to stand trial, apart from monetary loss, sacrifice of time and effort to prepare a defense, also causes humiliation and disrepute in the society. It results in anxiety of uncertain times. I'm sorry, my lord.
Yes, yes, it's all right. I'm just,
My lord, that is all, my lord. I wanted to bring.
yes,
to
answer
your lordship's
24. I've read it till 24.
attention. Yes,
So you have completed yours?
yes, my lord.
All right, in 5 minutes, Mr. Ahmed.
Lordship. Of the case, just one thing I want to point out before your lordship, that whatever your lordship said, that will have some bearing in the society, because this is the only recourse which the wife have in similar situations, lordship.
You see, that is a different aspect.
Lordship, lordship,
It cannot be said
lordship,
that in all cases,
lordship.
it cannot happen.
Yes, that can
Correct.
happen. Just I'm
A
yes.
husband is definitely, if cruelty is meted, if there are a breach of trust, one can. That is a different aspect. Cases are decided in the facts and circumstances of a particular
Lordship,
case,
lordship.
correct?
Lordship.
Now, in the instant case,
That
facts are before us.
lordship. Just for that purpose only, lordship.
406,
For 406
definitely
again, lordship.
no ingredients. 506, in the evidence, he
Lordship,
merely says he threatened to kill.
lordship.
No, and that is not supported by the witness who accompanied him.
But
He
there
never
are
said
other
anything.
witnesses, there are other witnesses also mentioned by him. Those witnesses are yet to be examined.
Mr. Counsel, the allegations are such
Right.
that it does not inspire the confidence of the court.
No,
The court is not going to the genuineness and all that right now.
lordship.
On the face of it, it appears to be highly improbable by applying the standards of a reasonable, prudent man
Right.
and absurd. Given that situation, paragraph 5, principle number 5 of Bhajan Lal clearly applies. Plus 7, it appears that because you have given the talaknama and his husband was living with the wife in her house with the parents,
Lordship.
father with the
And,
in-laws,
Lordship. And in fact, lordship, in this case,
and he has been thrown out of the house.
lordship. And in fact, in the
He has
present-
been thrown out of the house. Of course, while a husband and wife resides, they will definitely buy a lot of things together.
Lordship.
Now he says, no. She's refusing to return. He wants the mobile
Right.
back.
No, the only one thing, lordship, will
It
kindly see.
appears it has been maliciously filed, personal grudge.
No, regarding that ownership, lordship, I have already filed one interlocutory application enclosing all the vouchers. Those things, lordship needs to,
I do not doubt that.
lordship.
Which husband will not buy a mobile to his
Lord-
wife?
Lord.
After divorce, once the wife wants to divorce, now the husband will come to the court and file a criminal case and say, no, return the mobile, she's refusing. And it is a case of 406.
That
The court of magistrate, with all respect, without any application of mind, has set a criminal motion against the accused only on the ground of that. By how 406 can be attracted, Mr. Counsel?
that
Allah, center table. Thing is there is no allegation of fraudulent misappropriation, dishonest intention, nothing is there. Entrustment, what is the entrustment? What allegation of entrustment? He's staying there, he's bought it. Now, after the marriage is not working, now he will say, "You return it." She's not returning it, so he files the FIR.
But in other way, other
And,
way
and
also
based
still-
on these allegation, it appears that, of course, he has to make out some case.
Okay.
He's added those words.
Regarding 406, Lordship, that
Threatening has been added,
Lordship, in regarding
which is not supported by his friend.
Lordship. Regarding
see?
406, Lordship can also take it otherwise also that this was Lordship that she was the custodian of those articles, Lordship, that if custodians use the said article for her own use, then probably that 405.
Where are those? Where are those in his statement? In his evidence?
Because it is said in the complaint that he
But where
purchased
is
for
that
her.
in his deposition? You see, all the materials have to be.
Lordship.
Mr. Counsel, it doesn't.
That I leave up to you.
It doesn't inspire. It's highly improbable. I think, I don't want to say anything much, but
Then I leave up to you. Lordship.
merely because a husband writes in the FIR that the wife is trying to kill, threatening to kill, one cannot just simply on that basis. You have to see the attending facts also, which is coming out from the
Lordship.
FIR,
Lordship.
the evidences.
Lordship.
Everything has to be seen.
Lordship.
Just seeing that there is a threat to kill mentioned in the FIR is sufficient.
That I understand.
It has to be seen in the facts, because that is why the standards of a prudent man has been
Lordship.
also
Lordship.
laid down in the principle, because you see a lot of time these are misused.
Lordship.
A lot of time FIRs are being filed to harass people.
Lordship.
That is why this court, while exercising its inherent power for quashing FIR, has to be so cautious. Both sides. For both sides. Because an abuse of court process also cannot be allowed to be done,
Yes. That
isn't it?
Right.
Now here it appears there is a clear abuse of the court process.
to that I cannot concede.
Greg, you cannot, but you know in your hearts, your, your body language is indicating, Mr. Ahmed, I understand your limitations as the lawyer
Lordship.
for the complainant,
Lordship.
but ultimately you are also an officer of the court. Sometimes you need to concede. Highly improper.
Lordship.
All right, take it down. Heard Mr. N. Chaudhary, Learned Counsel, appearing for the petitioner. Stop. Also heard Mr. A. Ahmed, right? A.
Lordship.
Mr. A. Ahmed, Learned Counsel for the
For the
respondents.
respondent.
For the respondents. Stop. This petition, this criminal petition is presented, is filed under section 482 of the CRPC 1973, seeking quashing of complaint filed by the respondent, filed by the respondent on 22/8/2019, as well as the order dated 17/2/2020. It will have cost title to Belek sir. Quashing of the complaint filed by the so-and-so on so-and-so, alleging of being CR case number 251/2019 under sections 406, 506, 34 IPC. And the order of cognizance taken by the Additional Chief Judicial Magistrate Gwalpara under section 406/506/34 of IPC against the petitioners stroke accused. Stop. By order dated Diana. This is 17/2/2020. Stop. The brief facts of the case is that the complainant filed complaint on 22/8/2019 against the present petitioners, I wife stroke wife comma wife and petitioner 2 is mother-in-law
Yes.
and father-in-law.
And father-in-law.
Petitioner number 1, 2, 3. Petitioner number 1 or against it to me wife ko. Petitioner number 2 against a mother-in-law, 3 against a father-in-law. Before the court of addition, before the jurisdictional court, before the magistrate court, alleging inter alia that the petitioner number 1 at the instance of the petitioner numbers 2 and 3 demanded certain articles from the respondent, and the respondent, for the sake of upholding peace and had brought the same through his hard-earned money. It is the further alleged case in the complaint that the petitioner number 1, after a few days, started to threaten the respondent to end their marriage, and all of a sudden, on 19/7/2019, ousted him from the house of the petitioners. It further appears that it is further alleged that when the respondent went to the house of the petitioners to try to reconcile the matter, the petitioner number 2 and 3 verbally abused the respondent and also stop. Accordingly, the magistrate court on 17/2/2020, after perusing the complaint petition as well as the statement of the complainant and the statement of the witnesses under section and the witnesses took cognizance under section 406/506/34 of IPC against the petitioners accused. Situated thus, the present petition has been filed seeking quashing of the complaint as well as the cognizance taken by the magistrate court. Stop. Mr. N. Chaudhary, learned counsel for the petitioner, submits that it is amply evident on the reading of the allegations set out in the FIR that no ingredients of section 406 IPC is made out even if even if the allegations are taken to be correct in their face value. Stop. He further submits that the allegation of threat so as to attract the allegation he further submits that similarly the allegation as regards alleged threat as set out in the complaint is is also not sufficient enough to constitute the offense under section 506 of IPC. Correct?
Yes, madam.
He further submits that from the complaint as well as the materials collected by the prosecution, it is apparent that the respondent has lodged the complaint after he was thrown out from the house of the petitioner number 1, where he was staying with her along with her parents, and after receiving the talaknama from the petitioner number 1 expressing giving him talak.
Yes, madam.
Stop. He accordingly submits that it is clearly he accordingly submits that in the backdrop of such facts, it is amply evident that the complaint has been lodged with malafide intention and personal grudge solely to harass the petitioner number 1 and her parents. Stop. In support of the aforesaid submissions, he relies upon the principles, especially principle number 5 and principle number 7, enunciated by the apex court in the case of State of Haryana and others versus Bhajanlal, reported in 1992, Supplementary 1 SSC 335. He further relies upon the decision of the apex court in the case of Deepak Gaba and others versus State of UP and another, reported in 2023, volume 3 SSC 423. He accordingly submits that the instant complaint is a total abuse of the court process, and the order of the magistrate court taking cognizance under section 406/506 IPC is without any is totally mechanical and without any application of mind whatsoever, and therefore the said order is also and therefore the impugned order of the magistrate is liable to be set aside and quashed. Per contra, Mr. Ahmed Leonard, counsel for the respondent, submits that it is apparent from the averment set out in the FIR that the respondent with his hard-earned money has procured the items in the procured the household items, including mobile phone and gold ornaments, which the wife, after throwing him out from the house and issuing a talaknama, has refused to return the same to him, and therefore the ingredients of section 406 are clearly set out, are clearly being made out against the accused, against the petitioners stroke accused. Stop. That's what you are submitting, isn't it?
And wife is the only custodian of those articles as not
He
returned.
further submits that the wife being the custodian of those articles, the there is clear entrust, there is clear comma,
Ingredients of 406.
entrustment is there. Stop. He further submits that the allegation of, he further submits that the averments in the complaint as regards threatening, to the effect that if the respondent makes any future attempt of retrieving the articles, it would result in his death, is sufficient enough to constitute an offense under section 506 IPC. Correct?
Okay. And regarding petitioner number 2 and 3, there is specific allegation that they verbally abused the.
He further submits that there is also specific he further submits that it is specifically averred in the complaint that the petitioner number 2 and petitioner number 3 has verbally abused the complainant, and therefore a criminal offense is clearly made out. And hence the order of the magistrate taking cognizance of the offense of the said offenses warrants no interference from this court. Stop. I have given my prudent consideration to the arguments advanced by both the learned counsels appearing for the contending parties and have perused the materials available on record. I have also considered the case laws cited at the bar. Stop. The principles for quashing complaint stroke FIR is well settled. Stop. Apt to reproduce the principles enunciated by the apex court in the case of Bhajanlal Supra, which is reproduced hereunder for ready reference. Quote unquote, paragraph 102 and paragraph 103. keeping in mind the aforesaid principles. No, apparent reading of the aforesaid paragraphs, comma. In the event the allegations made in the FIR or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused, comma. The court is entitled to quash such complaint stroke FIR. It appears that even in a given case where the allegation made in the FIR or complaint are so absurd and inherently improbable, on the basis of which no prudent man can ever reach a just conclusion that there is sufficient ground for proceeding against the accused, comma, the court is entitled to quash such complaint stroke FIR. That apart, where a criminal proceeding appears to have been manifestly attended with malafide and or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge, comma, the court is entitled to quash the FIR. So complaint. Next one. Keeping the aforesaid principles in mind, let me now turn to the facts of the instant case. Apt to refer to the complaint, which is reproduced hereunder for ready reference. Quote unquote, A to A. Page 10. Okay. Mojot A to A course he delay ho. Apparent reading of the aforesaid FIR that it is alleged by the complainant that after the marriage of him with the petitioner number 1, he stayed in her house with her parents, i.e. petitioner number 2 and 3, and during the time of the marriage, she demanded few articles which are steel Godrej made of steel Godrej, which are Godrej steel, comma, steel showcase, comma, sofa set, comma, alna, comma, steel center table, comma, steel almari, comma, mobile handset, comma, and gold ornaments worth rupees 6,000. Few articles village kola tate full stop kore koba. It appears that accordingly he has purchased the articles being from his hard-earned money. It appears that later on the petitioner number one expressed her desire not to continue with the marriage and threw him out from their house on 19/7/2019. It further appears that thereafter it further appears that after being thrown out of the house, he on 3/8/2019 went to their house in order to went to their house and asked the petitioner number two and asked the petitioner number one to reconcile and reconcile their marriage and continue living as a family. But the petitioner number 2 and 3 verbally abused him. Stop. It appears that since the petitioner number one expressed her desire not to continue with the marriage, comma, he asked her to return the articles which he had bought. However, petitioner number one refused to allow him to take these articles and further threatened him that in case he makes any future attempt to take the articles, it would result in his death. It further appears that the petitioner number one has served a notarized talaknama, within bracket divorce deed, to the to him accordingly. It appears that based on such allegation, it appears that accordingly he filed the complaint for recovery, for direction for recovery of the articles from the possession of the accused persons. Stop. It appears that based on the, it appears that the magistrate court, after perusing the complaint, said complaint, as well as the depositions of the witnesses, took cognizance of the complaint under section 406/506/34 of IPC against the petitioner. Stop. Apt to reproduce the order dated 17/2/2020 hereunder for ready reference, quote unquote, page 23. In order to constitute an offense under section 406 IPC, comma, the word entrusted in the section in 406 is very important and unless there is entrustment, there can be no offense under 406 IPC. তার ওপৰত দি দিয়ে apt to reproduce 406 of IPC quote unquote section 406 দি দিবা হা 405 and 406 দি দিবা the basic requirements to bring home the acquisitions under section 405 of IPC are the requirements to prove conjointly number one, entrustment, and number two, where the accused was actuated, whether the accused was actuated by dishonest intention or not, comma, misappropriated it or converted it to his own use to the detriment of the persons who entrusted it. Therefore, unless such averments showing entrustment, fraudulent misappropriation, no offense under section 406 can be made out. Reading of the averments made, stop, huh? All right. Reading of the averments made in the complaint, even if are taken at their face value, comma, the same does not disclose any offense, does not disclose entrustment and or fraudulent misappropriation on the by the accused person stroke petitioners. Mere use of the word misappropriated in the FIR is not sufficient to constitute such an offense. It is apparent reading of the articles alleged to have been alleged to have been not returned by the petitioners are mere household items which is required for a husband and wife to comfortably live together as husband and wife. It further appears that the complainant has given a mobile phone and gold ornaments worth rupees 6,000 to the petitioner number one during their marriage. Stop. By no stretch of imagination, comma, it can be said that if the marriage does not work, or upon being served by a talaknama through the wife, it can be, and if the aforesaid items are not returned by the wife, a case of criminal breach of trust is made out. In fact, it is clear that such allegations are made in the complaint purely with the intention to harass the petitioners, for throwing the respondent out of her house, and for serving the talaknama. the order of the magistrate court taking cognizance under section 406 of IPC on the basis of such averments, where the basic ingredients of section 406 are lacking on the face value, appears to be very mechanical, appears to be a mechanical approach without any application of mind whatsoever. Stop. Undoubtedly, a magistrate is not required to go into the genuineness of the allegations made in the complaint, but none the same, a magistrate is required to apply its mind on the to the averments set out in the FIR complaint, as well as the initial depositions submitted by the prosecution in order to issue process, in order to initiate criminal proceeding against the accused. Stop. Therefore, I have no hesitation that the order of the magistrate taking cognizance under section 406 IPC is totally erroneous. This takes me to the offense. This takes me to the offense. This takes me, Ruba. This brings me to the offense under section 506 of IPC. Stop. Apt to refer to section 5 to the definition of criminal intimidation as provided in section 503 IPC, and the punishment for such criminal intimidation as provided in section 506 IPC for ready reference, quote unquote 503 and 506. Okay. It appears that in a reading of the aforesaid provision, it is apparent, it appears that before an offense of that the basic ingredient to constitute an offense of criminal intimidation is the intention to cause alarm to the complainant. By threatening with any injury to his person, reputation or property, or to the person or reputation of anyone in whom that person is interested. And or with intent to cause alarm to that person or to cause that person to do any act which he is not legally bound to do, and or to omit to do any act which that person is legally entitled to do, reference is made to the decision of Madhushri Datta, Supra, reported in this is a tax court decision.
Yes, madam, this is a decision of the apex court, madam.
Where, what is the citation?
Where the citation does not seem to be there.
It
I
seems
searched for it.
supreme today.
This is supreme today, madam.
Reported in 2025 0 Supreme within bracket SC at page 172. Paragraph 33, 34, 35, 37 is reproduced hereunder for ready reference. Turning back to the facts of the present case, it appears from the comma apt to reproduce the initial deposition of the petitioner, of the respondent, made under section 200 CRPC, quote unquote, page 4. Reading of the aforesaid deposition, it appears that the petitioner, that the respondent has stated, has deposed that he had brought, that while he was residing in the house of his in-laws with his wife, i.e. petitioner number 1, he bought household articles, namely Godrej, showcase, Dunlop, Alna, bed, mattress, and blanket. What is this? Blanket, 1 table fan, 1 ceiling fan, gas cylinder set. And after his wife divorced him by giving, divorced him through court proceedings on 22/7/2019, he along with Tahidul Ali and 2 others and few others went to the house of the accused, went to the house of the petitioners and asked them to return the articles, but they refused to return the articles and instead issued life threat to him. Deposition of Tohidul Ali, stated to have accompanied the respondent to the house of the petitioners, recorded under section initial deposition is also reproduced, is also reproduced here under for any reference. Page 22, A to A. Reading of the aforesaid deposition, apparent that the said witness has not, the said witness has that he has not, apparent reading of the aforesaid deposition, that the said witness has not mentioned the allegation of threat as stated to have been given by the petitioners to the respondent when they visited their house to bring back the articles. He simply deposed that the petitioners refused to return the articles. Stop. It further appears that he has deposed that it is as per the, stop. Thus, it further appears that the threat of death, threat of that the alleged threat of killing the alleged threat with death by the petitioners is also not reflected in the FIR lodged by the complainant. A complaint filed by the complainant. Stop. Be that as it may, this court at this stage cannot go into the reliability or genuineness or otherwise of the allegations made in the FIR. Stop. However, if the allegations are carefully looked into and assuming the same to be correct, if the relevant test is to take the averment set out in the complaint, so FIR, to be correct on the face of it. I'll continue at 2. Last paragraph. Test.
Sir, may I say one thing that my colleague will be here?
No problem, Mr. Amit. Mr. Deka, I'm in the midst of a dictation. I'll just finish it and I'll. One second. Bye. The relevant test therefore, is to take the allegations made in the FIR at their face value and accepting the same in its entirety if prima facie an offense is made out or not against the accused. Stop. In the instant case, I am of the view that the case clearly falls within the parameter numbers, within the principal numbers 1, 5 and 7 as laid down by the apex court in Bhajanlal Supra. Stop. It be worthwhile to mention that whenever an accused person comes before the court invoking the inherent jurisdiction under section 482 of CRPC to get the complaint, to get the FIR stroke complaint or the criminal proceedings quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with the ulterior motive for wreaking vengeance, comma, the court owes a duty to look into the complaint stroke FIR with care and caution, with a little more closely. Stop. In fact, while looking into the averments made in such FIR complaint, it is imperative to also look into the materials collected in the course of investigation and the other attending circumstances emerging from such record, from such materials, from such materials, over and above the averments made in the complaint stroke FIR. Stop. In such in the instant case, no, in the instant, in the in the instant case, the case made out by the complainant against the petitioner number 1, against the wife petitioner number 1 and her parents petitioner number 2 and 3 is for non-returning the articles which he had given, which he had purchased while living as while living as husband, while living as husband and wife at the, at her house. After being thrown out from the house and the divorce. Okay? In the context of an Indian society, it is imperative for an husband to maintain his wife during the time of marriage and thereafter, as the case may be. And during the course of such marriage, a husband has to purchase various household items, etc. Stop. Non-returning of the said items does not give rise to any criminal proceedings after the marriage is over. Non-returning of such items cannot give rise to criminal prosecution. So, the reference is made to paragraph 5 of the decision of the apex court in the case of State of Andhra Pradesh versus Golconda Linga Swami, reported in 2004, volume 6 SSC at page 522. Which is reproduced hereunder for ready reference. Quote unquote, para 5. Apparent that at the time of quashing, apparent that the court, while exercising, apparent that at the time of apparent reading of the aforesaid decision, comma, it appears that when a court is considering considering the prayer for quashing a complaint, comma, it is permissible to look into the materials to assess what the complainant has alleged and whether any offenses made out, even if the allegations are accepted in toto. Stop. Reference is also made to paragraph 6 of the decision of the apex court in the case of R.P. Kapoor versus State of Punjab, reported in AIR 1960, Supreme Court 866. Reading 6 and 7, para 6 and 7. Reading of the reading of the aforesaid decision, comma, it is apparent that the apex court has held that no doubt that judicial process, no doubt, should not be an instrument of oppression or needless harassment. Stop. Thus, the court should be circumspect and judicious in exercising discretion and should take all relevant facts and circumstances into consideration. And thus, the magistrate court should be circumspect and judicious in exercising discretion and should take all relevant facts and circumstances into consideration before issuing process, before taking cognizance of a criminal offense, comma. Otherwise, it would be an instrument in the hands of a private complaint to unleash vendetta to harass any person needlessly. It is obvious that at the same time, quashing petition cannot be used as an instrument to short circuit a prosecution and bring about its sudden death. Stop. In the instant case, another case, yes, this one. In other words, the court must cautiously examine the facts to ascertain whether they only constitute a civil wrong. Cautiously examine the facts to ascertain whether a criminal offense is made out or not. In the backdrop of the aforesaid, I'm of the, unhesitant view that the petition succeeds and is hereby allowed. The impugned order of the magistrate dated so and so is hereby set aside. The the complaint, the criminal proceedings arising from the CR case number so and so, dated so and so, is hereby quashed. It is needless to be clarified that the observations made in this judgment is only in the context of the facts and circumstances of the instant case. Stop. Dismissed, sorry, allowed.
Deeply obliged, my lord.
It is better to give that
But
because
that's
there are a lot
better,
of
my lord.
observations I have made.
Otherwise, there might be a genuine case later on. Somebody.
Correct. No, but non-returning of mobile phone and all these items, it's strange. At a line our piece of him that this the complaint is a gross abuse of the court process. I don't find him. All right.
Obliging.
It is not my touching case dillu. It to me yak baba.
May I please your lordship? Go back, go back. Judgment lordship was asking for, I think my junior colleague has provided 2006.
One sec, one sec. What did they have the work? 2000?
2006 5 SCC 123.
Your judgment will put us.
I'm looking at it. I'm facing a judgment.
2006
5 SCC 123.
It's not here.
Given a list of books, this will be get about that.
Aratasani. Yeah. Aji disso.
Para 8.
There are more decision in
There are,
this.
there are.
Yes, you see,
That is-
Mr. Deka, Ms. Bhattacharya, I have given my thoughts into the case. Now, there are two things. See, the reference, the way it is framed, is whether non-reimbursement of these medical bills amounts can be allowed in humanitarian ground. The moment the word humanitarian ground is used, it is presumed that there is no requirement in law for the management to give medical, to pay the medical bills which was in connection of cancer treatment. Correct? Now, if that be so, it appears that the entire case before the labor court went on a different footing. In fact, here also, the argument of Ms. Bhattacharya is that under the Act and rules, there is a requirement. That argument was tried to be developed, correct? And the court, labor court has also gone into that. Now, suppose I find that no, that the labor court ought not have gone beyond the scope, terms and scope of the reference. And the fact that this is already presumed, it cannot now be decided by the labor. These are if suppose I come to this finding, then what is to be done? The matter requires to go back to the labor court, or this court, while exercising 226, can decide that on the materials available. These are things which are going on in my
Exactly,
mind.
madam,
You think, or you don't have to react right now. Both of you, we have a long weekend. You think over it. Mr. Sharma, Mr. Sharma? Since you do a couple of labor court matters, the other day you had also answered a question when I simply called and asked you. So I was wondering if you can also assist us in this matter, only for that question of law which is involved. Because here the medical bill of the petitioner was not, of the respondent was not cleared by the management. And these are relating to cancer treatment. The reference was made whether on humanitarian grounds it has to be given. Arguments and everything went on before the labor court. There it appears that the provisions of the Plantation Act and rules were relied by both sides. The labor court has found that under the Act and rules, the management is required to pay and accordingly give a award for releasing the entire bill amount, which is incurred during the treatment at Bombay. So, reading of those rules, it is absolutely clear. By no stretch of imagination, the plantation rules will make it mandatory for a garden. These gardens can be of different sizes. Here, this garden is, I think, below 100
160,
hectare,
around 160.
below 500
employees.
hectare.
Below 500, not acres, no, employees.
No, okay.
Size, I am not sure.
I think somewhere I saw something. So they cannot have a
Cancer hospital.
garden hospital which would provide cancer treatment. That obviously cannot. Be that as it may, in fact, the reference also says humanitarian. So if you, Mr. Deka, can you make the copy of the petition available to
Yes,
Mr. Sharma? Let him also assist. He'll be a neutral person.
Yes.
So let us have his opinion also. When can we have it? This matter is also being. Otherwise, I had kept it for delivering the judgment today, but I feel from both sides, because suppose this court is also thinking another alternative, that this court will say the award is bad, but on humanitarian grounds, suppose this court can grant some amount, because there is a concession given by the management in their written statement that they are agreeable to pay the expenses that has been incurred at Assam. Because from the garden
Up to GMCH.
Which covers Jorhat and Guwahati. I
Jorhat
think.
and Guwahati. Because
Correct.
after Guwahati, they also went to a private place.
Bombay.
No. Here they went to a private
Acha,
place.
acha, acha, acha. All
From
right.
there they went.
All right. But there is now, apparently the bill which is on record is only the
There is
Bombay
nothing.
bill.
Yes, there is
The
nothing.
bill is Bombay bill.
Bill is Bombay.
So there is no material also before
And
the
on
court.
this, my lord, if your lordship permits me, I will take your lordship to paragraph 5 of my affidavit in opposition, my lord.
Just read.
Here it says, my lord, the deponent does not admit the statement made in paragraph 5 of the petition. In this regard, the deponent begs to say, this is our affidavit in opposition, submitted the workman approached the management regarding treatment of his ailing wife, and the management referred the patient to GST Civil Hospital Jorhat, from where she was referred to GMCH Guwahati, from where she was advised to take treatment outside MD Oncology. And my lord, it is during 2008, my lord.
That is all right. You see,
Therefore,
Ms.
I will add
Bhattacharya,
later portion.
now, just because Guwahati had referred her to Bombay, you have taken her to Bombay. The question is whether the management can be settled with that burden or not.
No, my
Because
lord.
ultimately, you see, to make that, there has to be first a obligation for the management to
No,
reimburse.
I will tell
Because the decisions that you relied are
Yes.
government
Your
employees.
lordship later portion, my lord, prior to take his wife to Bombay, the workman approached the management for financial help, but the management refused to provide financial help and advised him to take loan from his provident fund. Thus, it cannot be said that management had no knowledge and no prior approval was
Assuming the
taken by.
management had knowledge, Ms. Bhattacharya, how is it relevant?
No, my lord.
Because first
no,
of
my
all,
submission.
obligation.
No, my submission is that, my lord, this is unrebuttable statement, my lord. They have no.
I am not
this, my lord.
convinced on all this, Ms. Bhattacharya, but nonetheless, I'm
pointing-
trying to be sympathetic to your client
Yes,
because
that I understand.
that
my
is why I'm asking.
And
So-
another
One
thing,
position is clear that statutorily there is no obligation.
Absolutely, that's, there is no
Statutorily
quarrel,
obligation.
no obligation.
So only
No
consideration is humanitarian
No
law.
obligation.
the-
Mr. Sharma, the provisions are, you may just take a note. The Plantation Labor Act, Section 10,
Rules 35, 37.
Section 10 of the Plantation Labor Act. And in the rules, you will find Rule 35,
47 and 42, I think.
35, 36, 37, and 40, 42. Most important is 42, right, Mr. Dekka?
Yes,
42.
42 is the consequences of not fulfilling.
After holiday, let us all come with a
holiday.
fresh mind and rethink, because you see, otherwise I was very sure. So, but still, nonetheless, if something, and the other thing is, this is certiorari. Now, certiorari jurisdiction is only for correcting the error, correct? Can this court in certiorari direct something more?
I'll address your lordship on that
So
only.
you say I'm putting everything open before you three now. All right,
It may have to go back.
may have to go,
May have to go.
may have to go back.
With the
Because
limited scope,
that is
limited.
what was coming
yes.
to my mind.
With the limited scope that
But
if there
then
is.
again, you see, Mr. Decker, to send it back.
after
such
such a
old
long time.
matter.
Exactly.
Yes, my lord.
These are all things that I was, you see, I was having a disturbed sleep last night because of all this.
Yes, very
So I
important
thought,
it.
instead of rushing and giving a
Yes.
judgment today, let us,
We have waited from 14, my lord.
correct. So another three,
Heaven-
4
heaven
days,
will not fall.
3, 4 days, I think will go around.
Heaven will
So,
not fall.
when can we have it? Mr. Sharma, you also have a look at it. You have understood, and you are free to coordinate with any one of them if you wish to. Mr. Dekka, Ms. Bhattacharya, in
I'll
case-
give him a copy.
Yes.
And another thing, my lord, during that time, my lord, there is no advanced treatment of cancer here, my lord. So we.
I understand, Ms.
that is,
Bhattacharya.
yes. And
but-
because we,
But you see,
it took
if,
her to
and
Bombay, my
if
lord.
this court upholds this decision, it will open a Pandora's box.
Yes, my lord, yes. Now that I will
And
leave your
how do
lordship,
you
but I am
expect
pointing out, my
these
lord.
gardens, which has less
Yes.
than 500 employees,
Yes, my
to
lord.
provide cancer treatment in their hospitals
That
and
is-
not, and then to reimburse
now
bills
this-
sent in of
now-
Bombay and all that.
Now the
It is
situation,
not possible.
situation is different, my lord. At that time, my lord, we have to
I
take that
understand
risk.
now treatments are
Everything-
possible.
We have
at
to take that risk, my lord, because.
See,
because
that is the
we-
only reason the
Yes.
court is thinking
Yeah, that's fine.
equitable
Yes.
relief if anything can be
Yes,
granted.
oblige you to lordship, my lord.
That
for
is why,
my lord,
that
that's
is
fine.
why.
And the lady is
But
still
you see,
surviving.
Then again, this is tertiary. That is why I am
Yes.
repeatedly saying.
On 9th, my lord.
9th, yes, 9th to day. When is, all right. On 9th, should I keep it at 2 or we'll see, because it will come on the top anyway.
Anyway, let
in
it come.
part third.
Let it come.
My lord, in 9, we have some problem, my lord. It may be 7, my lord.
7th or not,
Yeah.
Just
Eight,
It may be
8, 10th, any day.
heard Mr. N. Dekka, learned counsel for the petitioner, also heard MSA Bhattacharya, learned counsel for the respondent. Though hearing was though hearing was concluded on 27/3/2025, the matter was posted today, giving liberties to the learned counsels for providing any judgment if they desire. Stop. MSA Bhattacharya has submitted the decision, one decision of the apex court, which is kept on record. It further appears that upon perusal of the documents and the judgments relied, the issue as regards the jurisdiction of this of this court, while the scope and ambit of the jurisdiction of the powers of certiorari in in testing the validity of the award passed by the labor court, as well as whether the labor court can travel beyond the terms of the reference, and in the event if the labor court does so, what is to be done? What orders can be passed, having been reasoned, comma, this court requested this court has fixed, this court deems appropriate to refix this matter on 9th, on 8th of so and so. Mr. R. Sharma, learned counsel, who is available in the court, is also requested to assist the court as an amicus curiae in the matter, which he has accepted. Learned counsel appearing for the parties are requested to furnish copies of the pleadings to Mr. R. Sharma, learned amicus curiae. Let registry also reflect the name of Mr. R. Sharma in the cause list as amicus curiae. Mr. Dekam, Ms. Bhattacharjee, there is no doubt you all have done your best, and I'm sure you will do. But just to get a neutral someone on this point, only for that.
Please, Your Lordship. Lordship, I'm for the respondent here, Lordship. Lordship, the learned conducting counsel, he was first up in court, Lordship. But the learned conducting counsel for the respondent, he was in court on first time, but first up, Lordship. But some difficulty, he left the court, Lordship. He also informed
Which matter?
26, Lordship. 26, Lordship.
My lord.
A counsel for?
Respondent, Lordship.
But in the first half,
Alright.
I have.
He was in court.
Yes, my lord, he told me, my lord. And I have requested him since it is 2021.
Yes, but if the
maintain-
he has
My
some
lord, I agree.
difficulty,
Yes.
we'll have it another day.
Another day, my lord, short day, my lord.
Mr.
MS Alam. MS Alam.
Mr. MS Alam, learned
Not
counsel
getting
for
the
the
maintenance. my lord. Problem.
petitioner submits that seeks accommodation for the day as the conducting counsel MD,
MS Alam.
as
Lordship.
Alam, learned counsel for the respondent, due to personal difficulty has to leave the court premises after the break.
Yes, Lordship.
Petition is not opposed. However, Mr. So-and-so, AK Hussain,
My lord.
a request, a short, fixing it on a short date, release such and such date.
Lordship.
All right.
Let it be 8. My lord, 8.
Lordship.
Hearing